So here in this case, courts have to decide between a maximalist understanding of free speech and a common good understanding of it. I think here the choice is clear. There is not a constitutional right to putting on drag shows in parks where kids are present. I think even if you mentioned such a possibility to the ratifiers of the First Amendment, first they wouldn't understand what you meant, they'd be confused, and upon understanding, they'd be horrified.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week we'll be covering an abortion case that was recently decided by an Indiana trial court. Then we'll cover the Fifth Circuit's recent decision regarding a Texas ban on sexually oriented performances in the presence of minors. Then we'll conclude with a little bit of coverage on a recently signed heartbeat bill in Wyoming. So let's start in Indiana. This was brought to my attention maybe a week ago, and I've read the opinion in detail and just published a piece on it, so we'll cover that in a minute, but let's just give the factual background. So Indiana law bans abortions in almost all circumstances. There's a ban on doctors performing abortions with some exceptions for the typical, rape, incest, and supposed life of the mother. So there was a challenge to the ban by a group of, two anonymous plaintiffs and an advocacy group called Hoosier Jews for Choice, who all claimed that their religious, spiritual, and moral beliefs require them to have access to abortion. They argued that the state's Religious Freedom Restoration Act, which was passed in 2015, subjects any law that substantially burdens their religious beliefs, which include the belief that they have a right to abortion in many cases, to strict scrutiny. So they claim that the abortion ban should be declared unlawful, at least as applied to them, given their supposed religious views. So a trial judge in Indiana recently agreed and issued a permanent injunction against applying the ban to the plaintiffs. There's an amicus brief filed by Beckett that came at an earlier stage of the litigation in this case. The brief notes correctly that the plaintiffs in this case lack standing since they face no immediate harm, but rather they make only speculative and hypothetical claims. That's all right. And I just want to note here that in the opinion, so presumably in the briefs and the actual argument, which I didn't read in depth, I read the opinion, obviously, but the standing and ripeness claims are prominent in the opinion, but I'm not going to cover them. They're legitimate, but I do want to focus on some of the more substantive legal problems going on in the case, which I think is probably more interest and concern to our listeners. So if you want a bit more elaboration on the ripeness and the standing issues, I would suggest you read the opinion. It's not very long. I think it's about 17 pages. And if you want more elaboration on the points that I'm going to touch on here, the substantive legal arguments, I just published a piece that should be coming out probably at the same time that the podcast does over at The Federalist. So a couple things I want to highlight. First of all, there are some really problematic narrative issues of fact that make for really bad law, and I just want to call them out. I think two in particular. So one, there's this claim from the court that one of the plaintiffs, quote, believes that at least prior to viability, a fetus is part of the body of the mother, end quote. And the court accepts this as a bona fide religious belief, which triggers the analysis that goes on in this case. My problem is that this is probably not going to be shocking or controversial to the people listening to this. That's not a religious belief. That's a scientific misunderstanding, right? So there's all kinds of rhetorical stuff that goes on here, right? People who want to support abortion can call an unborn child a fetus or a zygote or an embryo or what have you, but it's scientifically not part of the mother's body up until some arbitrary point in time, like viability, when it becomes something other than part of the mother's body. There's no transformation that happens at viability that makes the baby go from part of mom's body to not part of mom's body. Again, this isn't my opinion, and this is not a matter of religious belief. From the moment of conception, the unborn child, we can argue about legal personhood all day long, but the unborn child has DNA that is not the same DNA as that of its mother, right? So a part of a mom's body, right? Her liver, her foot, her heart, these all have her DNA. That's part of your body, right? Religion doesn't entitle people to their own set of facts about things that are scientifically obvious. So that's one problem I have with that argument. The practical one is that there's a slippery slope here to infanticide that is not obviously addressed by the court, but I think it's present in these arguments. And I don't think it's a stretch. I don't have to go into too much detail here, but if somebody can say that, well, my religious beliefs say that the unborn child in my body, even though it has different DNA than I have, is part of my body. Okay, because it's reliant on the mother for its nourishment or whatever, I guess, right? So how then can a different plaintiff with a different religious claim say that my belief is that an unborn child is part of my body, and then after birth, as long as the child is nursing, it's equally dependent for life on the mother's body, is it still a part of her body then for the first, 5, 6, 8, 10, 12 months of its life? If there's a religious right to say the former thing and then to end the unborn child's life, why is there not a religious right in my hypothetical to say that the nursing infant is also part of the mom's body and therefore also subject to her whims about killing it? I know that's macabre. I know that people might balk at that, but if you accept the first argument, I think it's very difficult to reject the second. So nobody's made it, but it's very concerning. You can look at the philosophy of people like Peter Singer, who have been claiming this for a very long time, by the way. This is not me making this up as a scare tactic. The idea that if you accept abortion as a right, the non-personhood of the unborn child, there's really no huge biological distinction that makes infanticide wrong, especially before the child before a year or two old probably doesn't have any more rational ability or intelligence, as Singer puts it, as like a pig or, the smarter animals. So be careful what you're doing here, because the logical conclusions of this can get quite bad. When you're accepting arguments for abortion, they can quickly become arguments for infanticide, whether that's your intention or not. Shifting gears, another problem I find in this case and in general in religion-related jurisprudence in recent decades is the relativist position American law has found itself in recent decades regarding what a religion is, right? It's clear from the court's record opinion that one of the plaintiffs, quote, does not believe in a single theistic God, but believes that there is within the universe a supernatural force or power that connects all humans and is larger than any individual person, end quote. All right. I think for purposes of the First Amendment, it's pretty clear. I've written on this extensively over the years. That's not a religion, right? Religion, you can use James Madison's line in Virginia that it's the duty that we owe to our creator. That's what religion is. It was pretty obvious through American case law through the 19th century that religion is theistic, probably monotheistic, and that philosophies that are humanist or political or whatever, they may be sincerely held, they may be deeply held, but they're not religions. But we've had a problem on this for 80 years now, right? Since the 40s, and then especially with cases like Seeger that I believe was in the 60s. These are conscientious objector cases where people who do not claim actual traditional religious beliefs but have deeply held opinions about war and things like that. And when those kinds of philosophical systems that are kind of like a religion are deemed a religion, then we get into this really murky place where we don't actually know what a religion is, and therefore we don't know what religious freedom is actually protecting. It's been a problem for a long time in the religious liberty movement, but the problem here is actually different, and I think even harder to get out of, because this isn't a First Amendment analysis where you're looking at the original meaning of religion in 1791. This decision is based on a Religious Freedom Restoration Act that was passed in Indiana in 2015. So original meaning analysis, originalism, textualism in this case with the statute, might have a problem here, right? What was a religion in 2015? Did it already encompass all kinds of heterodox, philosophical, and humanistic belief systems? Maybe. I don't know. I'm not a scholar of, this term in 2015 or what Indiana's legislature was doing, what the original public meaning would have been in 2015. But regardless, this leads to a place where, as the president of the Indiana Right to Life group pointed out in response to this case, RFRA, the Religious Freedom Restoration Act here, is being used to defend a practice that is contrary to life and religion, and it's something that nobody thought would be protected by the Religious Freedom Restoration Act. So I don't know how you square this. I don't know what the correct legal remedy is for things that are clearly not religions in any coherent sense that I can see are being protected by religious liberty protections. I don't know what we do, but I will just say that it's a problem, and here we are. So back to this case. The court touches on a couple substantive legal issues after dealing with the standing and ripeness issues. There are two basic arguments that are brought forth by Indiana, rejected by the court. One is that the that the claim that abortion is not sincere religious exercise, rejected by the court without much analysis. There's also the argument that prohibiting abortions, especially because it's not punishing women, but it's regulating when doctors can perform abortions, which is not often in Indiana. The court rejects that this is a substantial burden. The court rejects the argument that this is not a substantial burden on religious exercise. Again, not too much analysis, but the court says no, this is a substantial burden on sincere religious exercise. And I think anybody who cares about religion can see that we have a real problem here. If the supposed right to kill an unborn child is religious exercise, and any attempt to regulate abortion is a substantial burden on that religious exercise, we're in murky waters. So even if these arguments fail, right, you're like, okay, this is a substantial burden on some crazy version of religious exercise. Surely, I would think, once you subject this challenge to strict scrutiny, it's like, oh, okay, the abortion ban is subject to strict scrutiny. So then what does the Indiana government have to prove? That they have a compelling reason for the law and that this is the least restrictive way to achieve that compelling interest. So I would think that there's clearly a compelling interest here. It's to protect unborn life, right? Okay, you have a religious exercise right, but there are going to be plenty of other hypotheticals that you can imagine where, for example, if somebody has a sincere religious belief that they need to engage in human sacrifice, that the government's going to say, okay, even if that's a legitimate religious exercise, we ban murder in all forms, so we're substantially burdening that. We have a compelling reason to protect life in our state, right? That would clearly be a successful argument for the state, but for some reason that is not being applied to the unborn in Indiana. But the Indiana court here makes an interesting claim. First of all, there's definitely some doubt by the court as to whether unborn life is human life that is, that the government has a compelling interest in protecting, which is, of course, disturbing. But the court also says something interesting, which is that the exceptions that the Indiana law contains for rape and incest actually undercut the argument of the state. Which actually does make some sense. It's saying, listen, if the compelling interest that the government has, if it's strong enough to override religious exercise rights, why is that interest in protecting unborn life not applicable if the baby was conceived by rape or incest? So it seems, although I'm doubtful that a strict ban with no exceptions would have actually changed the outcome, given the other things at play in this case, but seems like a ban on abortion without exceptions would actually be stronger in showing that the government is stating we have a compelling interest to protect unborn life. It's a human life. It can't be killed when it's innocent. It's like, okay, well, if you have a secular exception, rape or incest, why don't you have a religious exception for these people who think that abortion is religious exercise? It's an interesting argument. We're going to talk about that a little bit in Wyoming in the last case that we'll cover today. But I don't know. We're in uncharted territory, and I think people who have been concerned about the shifting standards of what is a religion, what is bona fide religious exercise, there are some hard questions to be asked here. So the Indiana Attorney General announced immediately after this case that he plans to appeal the ruling. I'm curious to see what religious freedom advocates will do, what the Indiana Attorney General's office will focus on in their appeal. I think a lot of the arguments are still focused on standing and ripeness, but I'll just say I'm frankly not particularly optimistic. I'm concerned with where we've landed here. This is a bad place to be. As we fight to expand religious freedom, I think the movement needs to think very carefully to ensure that we're protecting religion from government interference without protecting, non-religious or even anti-religious and, in this case, evil practices.
Yeah, Frank, thanks for explaining what's going on here. I know you've done a lot of really important and great work on how do we make sure that expanded protections for religious liberty actually protect religion and not other things like abortion in this case. And just kind of to build on a lot of your comments, there's several lines from this opinion that help show really how off base this ruling is. And this is from the opinion, not from like a petition arguing against this ruling. The opinion notes that one of the plaintiffs, quote, does not belong to a specific religious tradition. She does not believe in a single theistic God, but believes that there is within the universe a supernatural force or power that connects all humans and is larger than any individual person. Another plaintiff, the Hoosier Jews for Choice organization, admitted to having no religious-based requirements for membership. So it's clear that there's no actual religious belief that is being protected here. It's a spiritual belief, or it's a political belief that's masquerading as religious by being slapped on as a belief on an organization that calls itself religious. Um, and like you mentioned, this is a RIFRA case. It's not a First Amendment case, so the originalist or textualist analysis would look different. But the reality is, if you looked at what the founding era definition of religion is, it's so far beyond, so very different from what's being argued here as religious. And we talked a bit about this last week as well, and you mentioned it, where a lot of state constitutions have worship Almighty God or the duty we owe to Creator as religion. There's nothing about a supernatural force that connects all humans. It's actual worship of a God. Uh, and like you mentioned, there's a lot about standing and if there's an actual harm being suffered by the plaintiffs in this case. And again, we won't get too much into the weeds. But one thing that just kind of stuck out to me as strange, not really from a legal analysis perspective, but just kind of weird and felt kind of out of the jurisdiction of a court, is that one of the plaintiffs in this case complained that her inability to obtain an abortion has caused, quote, decreased physical intimacy with her spouse based on this fear of pregnancy, and that is something that's fit for judicial resolution. And I don't want to spend a whole lot of time unraveling the kind of standing issues here, but it's strange to me that someone is asking a court to make sure that they can separate the possibility of having children from the marital act. Just to me, it doesn't seem like it's the court's role to make sure that people can supersede or create their own laws of nature. It's just not something that the courts exist to do. So again, not to get into the legal kind of analysis on the standing questions there, it's just kind of something that throws a red flag up as a potential claim in this case. So with that, we'll move on to our second update of the week, and we'll discuss the latest development in an ongoing lawsuit against Texas's law that bans sexually explicit performances from being performed in front of kids in public spaces. The facts are pretty simple because this is a facial challenge to this law. Texas law prohibits, quote, sexually oriented performances from being carried out on public property when there are minors in the presence. There are several organizations that put on drag shows in which men wear artificial breasts, dress as women, and dance and interact with audience members, often in very explicit ways. These groups claim that the ban facially violates their First Amendment right to free speech, and that facial violation is really important. So they actually haven't been subject to this law, but they say that on its face it violates their free speech rights. And these groups won at the trial level in federal court, and the Fifth Circuit recently issued another ruling in favor of Texas's ban, and this is on remand. So the procedural history is a bit complex. I'll just kind of breeze through it to make sure we can understand where this case is at. As I mentioned, the drag show performers won at the trial level. The judge issued a permanent injunction against the Texas's ban enforcement. On appeal, the Fifth Circuit vacated this injunction. That was back in November, and then just recently, a week or two ago, a panel of judges at the circuit level declined to rehear the case, issued another opinion, and remanded it back down. Again, ruling in favor ultimately of Texas's ban. So right now the ban is in effect, but this case is still being relitigated at the trial court. So based on the Fifth Circuit's latest opinion, it's likely that it's certain that the Texas law will be upheld. So let's dive into some of the actual issues that's going on in this case. So the Texas law states that, again, pulling from the law itself, quote unquote, sexually oriented performance cannot take place on public property and in the presence of minors. And kind of like the previous case we were discussing, a lot of the latest opinion focuses on standing. Some of the drag show performances were not deemed sexual under the law, and thus they wouldn't actually be subject to it, which it's an aside, but that's something that I would want to spend a moment kind of pointing out. The men in these performances are wearing women's clothes, wearing artificial body parts, highly sexualized. They're grabbing each other by the waist. They're passing out contraception and other sexual items to the audience members. They're dancing in ways that I certainly wouldn't want my kid to see. In some instances, they're touching attendees, sitting on attendees' laps. So there's very clearly a lot of prurient activity going on that seems like it definitely has a place to be regulated, especially in front of kids in parks. And again, that's not the crux of what's going on here, but I did want to point out that it's a little surprising that some of the groups were deemed not legally subject to this law. So on the standing part, because they aren't subject to the law, they don't really have a standing to bring this suit. But some of the groups, even under a very strict definition of sexually oriented that the court adopts here, are subject clearly to the law. I'll leave it to the listeners to read the opinion. They do things I'd rather not say where anyone can hear me say them or just at all. So I'll just leave it to you to read the opinion if you'd like to know what is actually going on that triggers the law's requirements. But for these groups that do have standing, basically there's two previous cases that come into play, and it really all centers around this being a facial challenge. So for one, the circuit court ruled against the drag performers' claims because the bar for a facial challenge to a law under free speech is really hard to pass. And the most recent test from this comes from a recent case called Moody v. Net Choice, where basically for a law to lose a facial challenge, this is coming from Moody, quote, a substantial number of the law's applications must be unconstitutional, judged in relation to the statute's plainly legitimate sweep. So basically, substantially more often than not, a law has to practically and actually violate the Constitution to lose this type of facial challenge. Now, the circuit court didn't actually say that the Texas law would pass the bar set by Moody or fail the bar set by Moody. It just said that this opinion was actually issued after litigation began, so it was never really brought up. So that's part of the thing that's being remanded back down, is to perform this Moody analysis of does this law substantially more often than not violate free speech. Secondly, the plaintiffs in this case claim that the law is vague, basically saying that the term obscenity and the sexually oriented performance is so unclearly defined that they're unable to tell what's actually being regulated. And here the judges ruled pretty similar to the facial challenge. The court said it's a very daunting and high bar to pass to declare that a law is vague unconstitutionally in a facial challenge like this. So basically, that's kind of what's going on legally here. Is the circuit court said there are these really high bars to facial challenges, and it probably isn't met, but it's going to be remanded and it's going to be decided. But really, the biggest takeaway that I see from this case is that it presents a great opportunity to review what the purpose of the free speech clause is and what the purpose of government more generally is. Now, if you believe that the government exists just to maximize individual freedoms, then really any cabining of free speech rights, especially in public spaces, is unconstitutional, right? If the government only exists to let me do everything that I want to, they can't tell me not to do something, especially in public. But if you believe that the government exists to actually promote the common good and uphold the common good, then this law makes a lot of sense in Texas. And I think that second understanding reflects the history of the First Amendment. Historically, the First Amendment was not used as a way to protect socially harmful or obscene speech, but was used as a way to really push speech towards being towards the common good. Now, I'm pulling a bit here from Adrian Vermeule's Common Good Constitutionalism, and quoting Judd Campbell in that book, he wrote that, for most of American history, the governing paradigm of expressive freedom was one of limited toleration, protecting speech within socially defined boundaries. So free speech traditionally is understood, yes, as free, but also as towards socially defined boundaries and towards the common good. Really, around the World War II era, did our free speech law become more absolutist or more maximalist? Even through the late 1920s, anti-blasphemy laws were actually upheld even in light of the First Amendment. Only then do we start getting rulings like Ashcroft, which is not as long ago in 2002, that held that the First Amendment protects the creation of virtual child pornography. So here in this case, courts have to decide between a maximalist understanding of free speech and a common good understanding of it. I think here the choice is clear. There is not a constitutional right to putting on drag shows in parks where kids are present. I think even if you mentioned such a possibility to the ratifiers of the First Amendment, first they wouldn't understand what you meant, they'd be confused, and upon understanding, they'd be horrified. So Frank, that's some of what I'm seeing in this case and why it's important. I'd love to hear your thoughts as well.
Yeah, not a lot to add. In case any of our more originalist listeners were triggered by a mention of Adrian Vermeule, I think this is very clearly defensible on purely originalist grounds. If that's your preference, I mean, it's obvious from the very beginning of the founding and of First Amendment jurisprudence. There have always been exceptions. Everyone knows that the rights in the Bill of Rights, especially free speech, is not absolute. We've had clearly defined exceptions to free speech. As you said, blasphemy is one of them. Inciting violence is one of them. There are several others, right? Everybody knows you can't yell fire in a crowded theater, and then when everybody panics and the fire department comes, you can't just claim free speech. This is obvious. One of those categories that's pretty clearly defined as an exception and not protected speech is obscenity. There have been tests that are developed, which I'm a little skeptical of the state of how these tests have narrowed, because there are claims that, like, if something has, I don't know the exact wording, like social value, right? Like then it can ideological content, right? Then even if it is pornographic, then it's not potentially not obscenity. I think that's a little bit absurd because you could clearly put a political or religious message into otherwise hardcore pornography and claim that it's not obscenity. I think that's absurd. I'll stand with Justice Potter Stewart, who was asked what obscenity is in a 1964 case. Says, I know it when I see it. Right? I think there's something of common sense here that like this is not what the First Amendment was ever meant to protect. If people who want to cross-dress or identify as something other than their actual sex want to demonstrate or talk about their rights, they're of course free to have rallies and give speeches and all of that. It does not mean that they're free to do lewd and obscene and inappropriate things in the presence of children. So I think it's just one of those things where, like, of course the legal tests are important, but this is just not protected speech. This is obscenity. And if there's doubt of that, that says more about the state of our culture than the actual state of the law. All right, with that, let's go to Wyoming and wrap up with our last topic. So Wyoming recently became the 5th state to enact a heartbeat bill and protect unborn life at the point that a heartbeat can be detected. This is not just the signing of legislation. There's some controversy and kind of an asterisk around on this one. So let's just talk a little bit about the background. So Wyoming's governor, Mark Gordon, just signed a new heartbeat bill, which bans doctors from performing abortions once an unborn child's heartbeat can be detected. That's important because it's any individual that performs an abortion on a child that has a detectable heartbeat or performs an abortion without checking for a heartbeat may face felony charges, carrying up to 5 years in prison and up to $10,000 in fines. So we discussed a couple months ago, I believe, the Wyoming Supreme Court case ruling that the previous abortion ban on the books in Wyoming from previous years violated a 2012 state constitutional amendment. And it was a really wild and problematic issue. The constitutional amendment in question, I'm just finding the language, says each competent adult shall have the right to make his or her own healthcare decisions, end quote. We're going to talk about the origins and the meaning of that constitutional amendment in a minute. But basically, in the last case, the court ruled that the previous Wyoming abortion bans were not narrowly tailored to the legislature's interest in protecting unborn life. This might be reminiscent of what we talked about a few minutes ago, that the former Wyoming abortion ban had rape and incest exceptions, as well as a fetal viability exception. And those exceptions didn't further the law's goals of achieving that compelling interest of protecting unborn life. So like I said, similar trend. When you have exceptions, it kind of undermines the idea that your compelling interest is to protect life, because you're clearly creating exceptions when you're not trying to protect life by the law. Notably, the newly enacted heartbeat bill that the governor in Wyoming just signed lacks those exceptions and is a straight heartbeat bill ban on abortion after fetal heartbeat is detected. So I think the tone is interesting to note. The governor of Wyoming supports the bill. He signed the bill, but in his letter accompanying the signing seemed to me less than enthusiastic because he knows Wyoming has this constitutional problem with that healthcare amendment, and he senses that there will clearly be legal trouble for this new law that he just signed. So as a quick reminder, the conflict in this now infamous case from a few months back from the Wyoming Supreme Court was that on purportedly originalist grounds, the court held that the state's abortion ban violated the Wyoming Constitution, which states, as I said before, each competent adult shall have the right to make his or her own healthcare decisions. The Constitution doesn't define what healthcare is. My personal opinion is that an originalist could easily find that killing an unborn child does not fit any sane meaning of healthcare, and so this shouldn't actually be a conflict. But that's not what the Wyoming Supreme Court decided. So it seems that the court here is content to include abortion in the healthcare provision of their constitution. Ironically, even though the purpose of the amendment was very far from trying to protect abortion, it's worth remembering that. Again, like we talked about with the Indiana RFRA case, where you have that kind of common sense. This is not what anybody thought they were doing when they were passing Indiana's RFRA. So when this constitutional amendment was passed in Wyoming, nobody thought that the amendment was passed to protect abortion. This amendment was passed in 2012 in response to Obamacare, and there was a lot of fear about federal healthcare mandates interfering with decisions like choosing your own insurance plan, choosing which treatments you're going to undergo, and so on. So clearly that was not the intent, but they did their whole public meaning analysis and said, well, healthcare, abortion falls under healthcare, so you can't pass a law in this case that bans healthcare, and abortion is apparently healthcare. So as it stands, then, if abortion is in fact healthcare, according to Wyoming's current Supreme Court, it's understandable the governor is concerned that this new abortion ban statute will be challenged, and I'm sure it will be immediately. So the question then is, what's different in this law that may allow it to survive? Now, I don't make judicial predictions. I don't know if it will in fact survive this Wyoming Supreme Court, but let's just talk about a couple of the things that are in this bill that might strengthen its survival under legal challenge. So there are very interesting and very good preamble paragraphs in the bill that lay out the argument as to why this should survive the court's scrutiny. First, while the court last year struck down the abortion ban due to the healthcare amendment, the Supreme Court last year also acknowledged, quote, that the legislature's authority under Article 1, Section 38C of the Wyoming Constitution to enact reasonable and necessary restrictions to protect the general welfare of the people, end quote. So now I want to read the next section here at length in this new law, because it lays out the case for why this law should pass muster under the Wyoming Supreme Court's evaluation of this constitutional amendment. So, quote, Article 1, Section 2 of the Wyoming Constitution recognizes that all members of the human race have an equal right to life. Unborn children are members of the human race. The general welfare of the state of Wyoming and its people necessarily includes the preservation of life. In State v. Johnson, the case we're talking about, the Wyoming Supreme Court acknowledged that the state has an interest in protecting the life that an abortion would end. The legislature finds that a right to life is the most fundamental of all rights, and the state has a compelling interest in protecting that life. And then to conclude, the last section of the preamble before they get into the meat of the law, quote, medical evidence shows a fetal heartbeat is a key indicator that an unborn child is alive and will reach live birth. The state has a compelling interest, beginning at least at the time a fetal heartbeat is detected. Note they don't eliminate the understanding of personhood from the moment of conception. They're saying at least at the time fetal heartbeat is detected, in protecting the life of the unborn child. Acting under the specific authority to determine reasonable and necessary restrictions on the right of healthcare access to protect the health and general welfare of the people, granted in Article 1, Section 38C of the Wyoming Constitution. The purpose of this act is to restrict abortion procedures on unborn children with detectable heartbeats, end quote. So that's the reasoning. I think it's very good. I think it's worth reading that preamble in full. So I guess the question, like I said, is what's the likelihood this law will survive the current Wyoming Supreme Court's scrutiny under the lawsuits that are clearly coming? I won't make a prediction, but the law does have a couple of things going for it. I think it's worth mentioning first that the law makes it a crime for abortionists to perform abortion. It isn't specifically targeting the woman making the quote-unquote healthcare decision. That's unlikely to convince a court once they see abortion as a healthcare right, because it's, again, similarities to the Indiana case, saying, well, if you're restricting doctors in Wyoming from performing abortions, then you're in fact restricting the option of individuals in the state of Wyoming to get an abortion. So I don't like the logic. I think this is specifically very different. This is targeting abortionists, not targeting the rights of people to make healthcare decisions at all. Don't know how successful that argument will be. I also do think that the removal of the rape incest exceptions is important, as it now shows that the state is consistent in asserting a compelling interest in protecting life from the time you can detect a heartbeat, period. Again, I don't know if that'll be accepted, but I do think it's definitely a stronger, more consistent argument. They're saying, well, we have this compelling interest. We're clearly acting on it because we're not allowing babies with heartbeats to be killed in any situation, right? So I think it's a good argument. I'm concerned that given the same court's bad opinion very recently, that we still are going to have a problem here. And it points to a bigger problem. It's a problem in Indiana. It's a problem here. Deeply conservative states are having the laws that their legislatures enact overturned by judges that are clearly out of step with the people there. Now, obviously, constitutionality is not a popularity contest. Something is not constitutional because 51% of the population says it is. But it seems to be common sense, at least to me, that a law meant to protect people from federal healthcare mandates being weaponized against pro-life legislation in a pro-life state is a major problem. Wyoming justices are appointed by, there's a nonpartisan committee and then appointed by the governor, who chooses one of the committee's 3 choices. And then there are retention votes every 8 years. So assuming that the current makeup of the Wyoming Supreme Court may vote the same way on this that they did on the last abortion ban, I don't know. It's rare to see judges ever lose retention votes. But I do wonder whether another adverse ruling against the law that is clearly being enacted by the people of Wyoming to protect the unborn might trigger a campaign against some of these judges. We've seen it before in other states. Like I said, it's very rare that these campaigns against judges are politically successful, but I do wonder if this would be enough to fire up the people of Wyoming, who, again, are deeply conservative. They're electing a governor and a legislature that are passing laws like this and then watching their own courts overturn them. Um, I, I don't know. I wonder if there's a backlash possible after that.
Yeah, Frank, thanks for the explanation here on what's going on both legally and culturally. And anytime we see a heartbeat law get passed, it's exciting. But like you said, there's an asterisk next to this one. So we'll definitely be continuing to watch and pray when this law inevitably gets challenged. And while it's a bit of an aside, I do want to zoom in briefly on the part of the Wyoming Constitution that you referenced and that the preamble to this law brings up. It's Article 1, Section 2. And that part of the Wyoming Constitution states that, quote, in their inherent right to life, liberty, and the pursuit of happiness, all members of the human race are equal, end quote. So that's why they're saying under the Wyoming Constitution, there is this understanding that all human members are equal in their pursuit of life. Unborn human beings are human life, thus they have the same protection. And I do want to point out that there's similar language in national level documents. Of course, it's not binding law, but the Declaration of Independence states that all men are created with certain unalienable rights, among them life, liberty, and the pursuit of happiness, life being kind of the key one that I'm trying to highlight here. And on last week's guest episode with Alan Parker that I spoke with, he's done a lot of great work on finding the right to life in the Constitution to protect the unborn. Specifically, he writes a lot about, and other people have done this as well, how the 5th and 14th Amendments both state that no one shall be deprived of life without due process of law. So it's certainly an aside taking kind of this Wyoming constitutional case to the federal side of things, but it is important to take the chance that there is this broader discussion going on about the federal constitutions possibly protecting unborn life.
Yeah, I'll just say one thing about that because I think I've done some research on the 14th Amendment personhood argument. I think it's good. I mean, if you look back at personhood, you have, first of all, you've had laws on the books that count, the killing of a pregnant woman as a double murder for a very long time. You could also go back into even pre-constitutional sources like Blackstone and find that when life began was thought to be quickening, right? When you could first feel the baby move, which is not an argument for viability, interestingly, because in the time that Blackstone wrote, when was the first time that you could be sure was that a woman was pregnant? Quickening. Now that we have technology to detect unborn life in the womb much, much earlier, in the first days after conception, I think it stands to reason. I think you could argue pretty persuasively that a coherent meaning of when life legally begins is when you can first detect that there is life in the womb and not at some later arbitrary point in time. So constitutionally, I think that's right. I will just give my pessimist's caveat on this issue because, well, two things. First of all, there are not 5 votes on the U.S. Supreme Court for 14th Amendment personhood. I'm not a predictor of Supreme Court outcomes, but I think that's, to me, pretty clear. I don't think it's there. But then the other thing, too, which is puts the pro-life movement in a really sobering position, is the poll numbers. I've written about this too, so I won't go on at length, but they're quite bad. I mean, even the amount of Republican voters, and not to be partisan here, but just the Republican Party is the one that tends to have a more pro-life platform. The number of Republican voters polled in a recent Pew research, I think it was in 2024 poll, the number of Republicans that support restricting abortion in most or all cases is barely a majority. Democrats, it's like close to single digits. So you just do the math, and like the number of people who want to restrict abortion among voters in most or all cases is like, it's bad, like 30% or so. And so this is not my original thought, but Ryan Anderson from the Ethics and Public Policy Center has pointed out that until we restore a sane culture on this issue, there's a limit to what we can do legally. And Ryan has opined before, and I think he might be right, that even if we got 5 justices to find personhood for unborn children under the 14th Amendment tomorrow, and so then all of a sudden, right, all abortion is now unconstitutional because unborn people have a right to life, I think you might see a constitutional convention, a constitutional amendment in America enshrining abortion as a right and clarifying that an unborn child is not a person for purposes of the U.S. Constitution. So I think it's important that we keep doing the legal work on the 14th Amendment, that we keep doing the policy work in state and federal legislatures. But the reality is, until the culture is pro-life, we're not in a very good place to have these laws survive the political process. So hate to end on a downer, but we're not doing well in the court of public opinion on this issue.
Yeah, I think we may have talked about this a bit, actually, when this podcast began, how religious liberty and kind of social justice isn't just a legal issue. It's a legal issue, it's a cultural issue, it's an educational issue. So it's so important to focus not just on building the right laws, but on building the right society.
Yeah, absolutely. Well, sobering note, but these are really important conversations. So with that, we will thank you all for listening and for joining us on this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you will like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you happen to be listening from. And if you want to learn about the programs that are going on, our upcoming lawyers conference in DC this April, any of the other things that we're doing, or if you want to support us financially, we run a lean, mean ship and would love your support. You can do that at napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.